All right, welcome everyone. Good evening, good morning, and good afternoon to wherever you are listening to me. Please, if you can hear me, you can just leave a comment and we get interactive. So I can see my guest, Steven is in there, Esther is in there. So thank you so much. Please, if you can hear me, good evening wherever you are watching us from. If you can just let me know where you are listening to us from in the comment section. I'll be grateful if you can share with us wherever you are listening to us from. So we are streaming on Facebook, we are streaming on LinkedIn, and we are streaming on YouTube. Okay, Chantel. All right. Margaret, thank you. Margaret Ababese. Hi, Margaret, how are you doing? Thank you so much for joining us. Okay. Gifty from Ho, Vida from Great. Before that, if you have any question, you can just leave it in the comment section and we can take it from there. So we are waiting for one of our moderators to join us. That's Dr. Jeff Bassay. He was actually in class, so he will join us shortly and we start. All right, thank you so much. Madam Esther, welcome.
Thank you, Humphrey. How are you?
This is Kabnak. I'm doing so well, and you?
Okay, Komina, how are you?
I'm doing so
Don't
well.
mind me. So, the guy who called said his name was Humphrey and he introduced himself as being the coordinator moderator.
Oh, okay.
I thought he is on
I
call.
asked him to call you because I was here preparing.
Then
Right.
sorry for the misidentification.
Madam Esther, this happened last time. I also mentioned your name, and it was also I think Ataka.
Ayo, thank God you have Tika.
Esther, thank you so much for being here. So I have Stephen. Good evening. If you can hear me.
Hi, good
Hello,
evening,
Stephen.
Kwabna. Yes, Kwabna.
Yes, Stephen, can you hear me?
Yes, I can hear you loud and clear. Can you hear me too?
Hear you. I can really hear you. I can't wait to see your image.
Just 1 minute. Okay, there you have it.
Yes.
You are looking fresh. Now that you're born, so if there's an agenda, let me know so that I can also dress appropriately and follow you.
It is well.
Yes, sir. Good evening.
Good evening, my brother. Do you think you need dressing? You are already dressed up. So just follow Kwabena.
The way Kwabna is all hyped up, Charlie. Hey, I'm even scared.
Meanwhile, today is Saturday, Kwabena. Do you see the way I dressed?
Yes, I know, right? I know.
Today I'm representing Davi.
Straight.
Okay. All right. Thank you so much for making time for today's discussion. So I think we will be left with Dr. Jeff Bassay to join us. He's currently in a session, so he'll be joining us shortly. But just in case you are joining us on Instagram, on LinkedIn, sorry, on Facebook, on LinkedIn, on Facebook, let us know wherever you're watching us from. So I have a few comments here. Someone said he's joining us from Ho, all the way from Ho.
Okay.
Another person said he's joining us from Accra. Yeah, Ho. Yes, another person said he's also joining us from Spintex. All right, so thank you all for making time for our discussion. And as always, we just want you to know that this webinar is proudly sponsored by the HR Certification Center. So give me just 2 minutes to talk about the HR Certification Center. And I believe that It will benefit all of us. So, as an institution, we provide preparatory skills for HR practitioners who are looking at. Okay, I can see the comments coming through. Hi, everyone. Thanks to HR certification for this event. You're welcome. Very happy. All right. So we just want to let you all know that we are currently open to admit HR practitioners who want to get certified with our institution. And as always, HR certification, we are committed to a higher standard. So we just want to let everyone know that our institution is open. So we are currently we are doing intake for cohort 40. Cohort 40. So just in case you are an HR practitioner here, we encourage you to join us. So you can just call us on 0244 122 855. You just send us a WhatsApp message that, hi, my name is Ama. I want to join your professional certification courses, and our team will attend to you nicely. All right, so let's dive deep into our discussion for today. But before that, what we are discussing today is on the labor laws of Ghana. And I believe that it's imperative for all of us here to know what is new and keep ourselves updated. So as an institution, we provide 3 professional certification courses, which is Associate Professional and Human Resource International. And this is for those without degree, those with no work experience. This one is an online session, so you can join. So if you look at the graphics I've shared on the screen, you will see that we have module 6. You will see M6, which is the labor laws of Ghana. So when you enroll, you get the chance to meet our facilitator, Stephen Osei-Kisi, to take you through that particular module. So if you have no degree, if you have no work experience, we recommend the Associate Professional in Human Resource International to you. And all right, so, and if you're also a bachelor degree holder, you have degree in any field with 2 years working experience, we recommend Professional in Human Resources International for you. And that one too is a 6-module course, and you are likely, not like you are likely, you will enjoy a module 6 course, which you meet Mr. Osei-Kisi and Dr. Bassay, one of our facilitators here. You join them, and we finally have the senior Professional in Human Resource International. So this one is what we recommend always to people with master's degree, people with years of experience in practicing HR. So we just want to encourage everyone here who is an HR practitioner to join us. You can just send us a WhatsApp message on 0244 122 855. 0244 122 855, and our team will respond to you as soon as possible. So we are still waiting for one of our facilitators, but just before that, in-house we have a new program we want to enroll effective next month. So if you can see on the screen, we have legal training for HR and line managers. Legal training for HR and line managers. We believe that as an HR or a line manager, once you are working with people, it's imperative to know some of these laws that governs everything we do. And the modules, let me take you through the module quickly. We have the foundation of the law, Labor Law 2003, Workman's Compensation Law, HR policies and the law, employment contracting, employee discipline and termination. So this particular program starts from the 9th of October to November 15th. And it is in person. That means you have to visit our office at the East Legon behind GT Bank. That is the Bassay Street. You can call the number on the screen 020-800-7585 just in case you want to sign up for this professional course. As always, as an institution, we provide a lot of workshops, and we have ethical culture and integrity management workshop, which is starting on the 28th of August 2024. This is online, and we recommend it to every line manager, supervisor, HR manager, HR director, HR professionals, and a business manager. So you can also enroll for this short course by calling us on 020-800-7585. All right, so we are going to have an insightful discussion today. So just in case you have any question concerning the labor laws of Ghana, we recommend you jot it down. And all right, so Dr. Bassay is here. Dr. Bassay, please, can you hear me? Whoever can hear me, please. Good evening.
Hi, Governor, good evening to you and to our August participants.
Good evening, Doc. It's a privilege to have you here, Doc.
Yes, it's a pleasure. Thank you for having me, sir.
All right, welcome, Doc. So, Doc, you will give us an open remark. I just want to throw it straight to you to start the whole session with us. So if you could give us an open remark, it would be great for us, Doc.
Well, like I always say, the function of an HR professional, and if you may, expression of knowledge of the labor law is in tandem. You cannot be a good HR without appreciation of the labor laws. In other jurisdictions, I mean, specifically the US, for instance, nearly half of all HR practitioners are qualified lawyers. The others who are not even qualified lawyers have very good appreciation of the law. They either first degree or LLB holders in law, or they have attended a lot of legal seminars, or they have very good lawyer friends they keep under their armpits who advises them every now and then. It may not be the case in Ghana, though we have a few HRs who are lawyers. But whether or not you're a lawyer, you don't really need to be a lawyer to make a good HR. But what I'm saying is that you need to have a good appreciation of the labor laws, especially because, people management is a strategic function. But people management is also not left to the whims of an employer that is represented by the HR. It is heavily regulated by law, and if you do not play by the rules, you run the risk of driving the organization into avoidable liabilities. Yeah, Kwabena, you are muted, please. Yeah.
Doc, thank you so much for the intro. And Doc, our discussion is going to focus on employee disciplinary process. So that is what we are going to talk today. I know you have a lot of experience from this particular topic. And so I would like to ask you the first question that we start our discussion. Doc, what actually constitutes fair disciplinary action under Ghana labor law? That's the first question I want to ask you.
All right. Knowing that there would be follow-up questions, and if time allows you, you're going to take, questions from the general platform or practitioners.
Hi, Doc. If you can hear me, you are muted.
Yes, I'm good. Sorry. So knowing that you are going to ask other follow-up questions, I'll just give the synopsis, if you may. Employee discipline, it has a procedure, and like we always say in law, procedure is as important as substance. You can have a substantive case. I mean, I've handled quite a number of them at the Labor Commission, where an employee truly had committed an offense, has breached a policy. In some cases, have even stolen, and there's evidence to that effect. But the employer sidestep processes in disciplining the employee. And so I'll just mention the points, and then as the conversation goes on, we can explain them further. The first obvious thing you do when an employee is suspected to have breached an employee is suspected to have breached a policy or committed an offense is to want to issue a query. And based on the response to the query, if there is any reasonable cause that the employee had committed the offense, you would want to investigate the offense. There are fundamentally two types of investigation. I guess we will explain them as we move along. Inquisitorial investigation and acquisitorial investigation. Once the investigation is complete, the reports will go to management who sanctioned the investigation, but the findings would have to be shared with the suspected person. We all know the rule of natural justice. An innocent person is presumed, or a suspect is presumed innocent until proven guilty. And so those two natural rules of justice will apply. The first one is the audi alteram pattern. You cannot punish a person without giving him a hearing. And then the nemo jude in causa sua, how you cannot be a judge in your own cause. So when the investigative reports come, the findings, we have to serve the employee who had allegedly committed offense or breached the policy. Thereafter, we will invite you to a disciplinary hearing. Now, what I'm describing applies more to punitive offenses. For non-punitive, we normally use the progressive discipline, where you do verbal warning, written warning, etc. But for the punitive offenses, we would have done hearing and go through we have to tick all the boxes to prove culpability. Once culpability is proven, we can then go ahead to issue a punishment to the person. So in a snapshot, this is how the disciplinary process looks like. And I mentioned that procedure is as important as substance. If you sidestep these processes, a person who hitherto should be punished could go scot-free. And in course of our conversations, I would refer us to some Supreme Court rulings according to Ghana Law Report to this effect. Right. So that is what I have to say on the processes.
Thank you so much, Doc. But Doc, I have a question. Let me continue with another question. Can an employee appeal the disciplinary decision?
Oh yes, most definitely. The appellate system. Now you see the internal employee discipline in the organization mimics that of what happens in the law courts, if I may say so. So the employee have the liberty to appeal, especially when he has reasons to believe that he either didn't commit the offense or that he committed offense, but the sanctions, if you may, the recommended punishment do not commensurate the offenses. The employee can appeal. I say it mimics a court proceeding because even at the disciplinary hearing, the employee have the liberty to cross-examine the witnesses that the employer indicates, the investigator indicates in the investigative report. The employee can ask that those witnesses are brought to the hearing for him to cross-examine them, practically in an attempt to discredit their witness reports. I mean, for want of a composite expression, if I could say so. So he has the liberty to appeal the process.
So, Doc, if an employee misconducts himself, either at workplace or at an event, can the employer terminate his contract immediately?
Well, there's nothing called immediate or instant sanction under any circumstance.
Okay.
As I mentioned, the processes, if you sidestep them, it's like asking me If a police officer arrests an armed robber on the robbery scene, can the police officer drive the robber to Nsawam prison? No. You arraign the robber before a law court. So there is no such thing as I have dismissed you immediately. It is alien to our laws. That's the first one. Now, the substance of the question you are asking is for a misconduct. The question will be what kind of misconduct? But let me clarify that you don't declare an act as an offense at the whims of an employer. If stealing goats in Ghana was not in our criminal code, all goat thieves will be considered angels. You must define the act as an offense to be able to sanction an employee who is in breach of that offense, because justice is delivered on law and law only. Let me say so. Justice is not delivered on morality, on ethical conduct or common sense or religious beliefs, blah blah blah. What does the law say? So if the law is not speaking against that, and by law here, I'm referring to both the state regulation. I mean, we have the Labor Act 651 2003, the Workman's Compensation Law, the Factories, Offices and Shops Act, the LI 1822, LI 1833. All of them are state regulation. The employer's internal policy are also laws, except they are soft laws. But because laws are in hierarchy, you cannot have a provision in the employer's policy that runs counter or that contradicts what is in state regulation. For instance, the state regulation says in section 20 of the Labor Act 651 that leave shall be a minimum of 15 working days per annum. You can't go and have a policy or sign a contract with an employee that says we'll give you 12 days, and then you insist that because it's in the policy. Because what is in your policy contravenes what is in the Labor Act, to the extent of the contravention, it will be void, because you cannot unilaterally or two people cannot agree to contract themselves out of state regulation. And so our internal policies must be analogous to state regulation.
All right, thank you so much, Doc. Just in case you just joined us, let me take you through this new program we are enrolling here at HR Certification Center. This program is for line managers and HR practitioners. So the name for this particular program is Legal Training for HR and Line Managers. So let me quickly take you through the modules that this particular course offers. So we have the foundation of the law, Labor Law 2003, Workman Compensation Law, HR Policy and the Law, Employment Contracting, Employee Discipline and Termination. So this particular program starts from the 9th of October to November 15th, 2024. So if you want to sign up, you can just pick the number on the screen. Let me mention it so that we can all jot it down. 020-800-7583. I take the number again. 020-800-7585. I believe this course will actually help all of us. Now, Madam Esther, can you hear me? Hello, Madam Esther.
Yes, please. I can hear you.
Great. Madam Esther, I have a question for you. In the case of summary dismissal, is the employee entitled to payment of accrued leave days at the time of the dismissal?
Thank you. My camera is giving me trouble, so I've switched it off. My son is trying to work on it for me. In case it's come up, then I'll come back again.
That's fine. That's fine.
Thank you. Good afternoon, everyone. Good afternoon, Dr. Bassay. Good afternoon, Stephen, and everyone on call. My name is Esther. It's really a pleasure to join this panel and the opportunity to discuss with everybody who is on call about our workplace issues, especially with regards to labor laws and its application with those of us who are working in the employer-employee relationship is very, very important. We know the applicability of the laws that we are working with. Like doctor's introductory comments. Those days when we joined the workplace issues, you are supposed to read the Labor Act from first page to the last. So it's very, very important we know the rules and the laws that are governing the workplace relationship. And as HR, is one of the very, very significant things that you know that will help you work around your employer and the workers and the team that you are working with. It's very, very important. So there's workshops and seminars and webinars like this is very important for all of us to learn a thing or two all the time to help us navigate around the workplace. You ask whether termination and whether somebody who is dismissed can be, come again, what's his name? Kwabena.
Madam Esther, so I asked
Come
that
again so that
so I asked that in the case of summary dismissal, is the employee entitled to payment of accrued leave days at the time of dismissal?
yes and no, depending on the procedures and policies that we have put in place in our condition of service, in our collective agreements, is very important. And even in our contracts. When we started working in the trade unions and the workplaces, we mentioned summary dismissal to be a very grave misconduct. We call it major misconduct. That if you are found to commit such offenses, when you are dismissed, you forfeit almost all the benefits that will accrue to you as a worker. But as we move on, for the workplace, it is not governed by only individuals or only that employer. Everybody else is looking at us. Any other person too who is working in that environment, who is also a worker, is looking at us. So we are changing. We deal with these cases on individual basis. What are the issues? Like you and doctor discussed earlier, you cannot terminate somebody instantly. The investigations that come into play before the person is being dismissed, because you can't see me and say that because I've assaulted somebody, because I've been seen to stolen, or somebody says I've stolen something, I am being dismissed and I'm forfeiting everything that accrued to me as your employee or as your worker. You can't do that to me. So if I am being dismissed, what happened? We have various entitlements under our sleeves as workers. So let's define what a summary dismissal is first, before we will come to whether we will have to forfeit that as an employee or as a worker when we are found to be against the rules or the laws of the organization. Summary dismissal may be maybe termination without notice of a gross misconduct. Major or gross misconduct, that's how we call it in and this come as if you are a thief, you are found to steal something, there's a fraud, there's a violence, there's a breach of a company policy that we all think is something we cannot condone with. Even that, we have to investigate. After the investigation, if I have my leave, every organization have procedure for going on leave. If I have my leave days that I haven't used, you are supposed to give it to me. If I have my PF that I have contributed voluntarily to, you have to give that to me. But some organizations have procedures for it. We have the PF to be ABC, the employer's contribution, the worker's contribution, and the interest on it. In some organization, in their procedures, They mention in their collective agreement or the condition of service that if you are found to have done something that they've deemed to be a misconduct, gross misconduct, and they've taken you through the process, they are in the process, you will take only the part B, which is your contribution, and maybe the interest, but the employer will not give his contribution, which is the A to you. But the leave days, every other end entitlement that you have to be given or take it before you go. And others too, depending on what we have written in our policies that we have signed on to. Anything that you sign on to that does not contravene the law, you have to make sure, you have to be aware that they will implement it on you. So if in your collective agreement or your condition of services say that under summary dismissal, they will not pay you any severance, your leave will not be commuted into cash and give to you, depending on the offense, then you have signed to that. So it's very, very important to know that the rules that we set up in our workplaces have to be reviewed regularly for us to know what we are signing on to. And when they have review it, they have to socialize it with us. Some of us too, we don't know what happens in our workplace until we are terminated or we are dismissed. So these things are not cut in stones or is not a blanket policy for everybody. Every organization have set up their own rules, and each individual who works in that organization have signed on to it. So if you sign on to it that, for example, there's a CA that I've seen in one of the hospitalities that you are entitled to an end of service benefit if you have worked there for 15 years plus. But under that, when you are summary dismissed, you are not entitled to that. So if you sign on to something like this, I cannot say, or we cannot say that because summary dismissal is not specifically stated in the Labor Act or anywhere that if you are dismissed summary, everything should be given to you, or you are entitled to things that you've earned. You have to be paid end of service benefits when you are working in this environment. And so it depends on the things we sign on to and the level of the grievances or the conflict, not even conflict, the what do we call it? The misconduct, sorry. So let's say, for example, somebody has embezzled, fraud, taken a lot of money from the organization, and we took him through the process, and we've seen that really there's evidence that he's done this, I've taken this much of money away from the organization. We can take him through the official legal processes of the country, but it will not be helpful for the organization to add money to all this to him. That will not serve as a deterrent enough. So these things depend on individual basis and the rules that we have set for ourselves. Previously, when you look at all collective agreements, summary dismissal, we are supposed to forfeit everything, every end benefit. But today, a few cases that we've seen, even when you are dismissed, they gave you the things that you have earned. It's only that the organization will not add their part of it or anything that they have stated that any employee who is exiting properly, like retirement or retirement officially, compulsory, or medical retirement and give to you, no. But if you are summary dismissed, they will not add anything to what you have earned.
All right,
So
Esther,
that
thank you
is
so
that.
much. Esther, let me ask this question. What's the difference between dismissal and termination? If we could throw light on this.
Termination is the end of the employment contract that we have.
Okay.
We know that in our jurisdiction here, there is nothing like employment of servitude. So in a layman's term, when the two of us agree that we want to work together for a number of years, for a number of months or whatever, because under the law, everybody is a worker, whether you have a 1-day contract, whether you have 2 days contract, whether you have a contract of permanency. That's we call it permanent space casual contract. Whatever contract you work under, there's nothing like you will not end it. So if I decide that, oh, I'm resigning, we are terminating the contracts. If the two of us come together mutually to end the relationship, we are terminating it. If in my contract we said that after 1 year, either of us can terminate the relationship, that is it. We can terminate. And depending on what is written in our contract, and even another official one that we have in our laws, in the Labor Act, is redundancy. It's a termination. You can even be found not to be competent. It's a termination. You can even, when you die, you have terminated the contracts. You see. So for the contract termination, it comes in different ways. Redundancy, end of the contract, the two of us are not willing to go on with the relationship. You are found not to be competent enough. There are paperwork. They've appraised your work. They've got to take you through PIP. They've done everything possible. You have been trained and retrained. And they see that you don't have capacity to perform the role in which you are. You can be terminated. Those are the termination under the law. So that is it. Even medically, if you have been found that you are not medically fit to perform the role for which you have been employed, termination will come. But under all this, you have to make sure that the procedures that you've set in place, or the clause that is in your collective agreement, that is in your contract of service, that is in your condition of service, is followed through. Procedure is everything as far as the workplace governance is concerned. When you follow procedure, either of you can terminate the relationship. That is why even under resignation, you are supposed to give your employer a time of notice for him to replace you or reorganize himself so that your role will be occupied or may not be left unattended to. So that's what the termination is. It's just ending the relationship that the two of you have under different circumstances.
Thank you so much, Esther. Osei-Kisi, are you here?
Yes, Kwabena, I'm right here with you.
Yes, Stephen, I have a question for you.
Okay.
Can an employer refuse to accept an employee's resignation letter?
Okay, so I think that one of the things that we should all come to terms with, and I think Doc and Madam Esther have gone in other ways to try to make us understand this, that the employment relationship is not that of servitude. And so when we are in a relationship and it's an employment one, and I feel for whatever reason I don't want to stay, then once I tell you that I am leaving, then automatically, ideally, you should not have an issue with it, because, like we have all tried to explain, it's not that of servitude. So whilst I am giving you the appropriate notice, then ideally, it shouldn't be an issue when I tell you as my employer that I'm leaving, or when the employer says that, well, these are the circumstances under which we can also make you leave. And so if we have satisfied it, then it shouldn't be an issue. But in respect to your question, yes, the employer cannot say that you will not accept an employee's resignation. No, you cannot do that.
Thank you so much, Osei-Kisi. Thank you so much for your insight. Dr. Jeff, Bassay, let me throw this last question to you. We have a few minutes to end this session. Just now. Wow.
Time flies.
Yes. It's been an insightful discussion. Doc, what steps can an employer take if an employee is constantly late to the office? You have this staff, he's always late to the office. What action can you take?
Right. So that I would fall within what we call non-punitive offense. You don't just terminate appointments because an employee is late for the first or second time. That would have been like trying to kill an ant with a smear hammer, you know. So when an employee is found to be constantly late, you activate your progressive discipline. The first thing will be to probably like coach the employee. He may need to know or understand that his lateness is affecting the organization. There are people who, especially in our part of the world, we even are bold enough to call something Ghana man's time. I don't know how our time is different from the rest of the world, because sometimes people get late and when you complain, you're like, but it's only 4 minutes late. If you are late for a minute, you are late. Okay, so the person may probably need to be coached. I mean, to appreciate the fact that the organization doesn't tolerate lateness and the fact that your lateness is affecting the organization. And you probably want to preview what is likely to happen to the person. If it happens again, then of course we go to what substantively you should do is to warn the person. Verbal warning is what we normally will recommend for the first time. You verbally warn the person, but document it and put on the person's file. If the same offense is repeated, that's the lateness, then you want to go into written warning. It happens again, you may want to issue a written reprimand, more like with a threat of termination. Depending on the organization, you may, you see, when it continues, and then it becomes a disciplinary issue. And so all I have talked about will have to be activated. You need to query, you need to give the person a hearing, blah, 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 blah. And then you come to a conclusion to punish the person. Now, suspension is a disciplinary punishment. So those who suspend and then later hear the employee, if the offense is committed again, no. The only thing you do before hearing can be interdiction, but interdictions are applied to punitive offenses. So before you suspend, you want to give the opportunity to the person to be heard. The same offense is committed, eventually you can separate the employee. Indeed, I'll be happy if my colleagues, Madam Esther and Steve, can or would want to add their voice to this. So that is it. From I normally would advocate or would recommend coaching. Somebody would likely start from verbal warning, but I say you should first coach the person. If he doesn't stop, you give verbal warning. He doesn't stop. Written warning. He doesn't stop. A reprimand, probably with a threat of termination. If he doesn't stop, you may suspend just to save this. Otherwise, then you would want to go through termination. But all of these must be done procedurally. Let me sound this caution. Sometimes there are organizations who are tempted to take money from the employee's salary. You are late, so we are going to deduct 50 cedis from your salary for today. It's illegal. You want to read Section 69 of the Labor Act, which protects the employee's remuneration. And it says that pecuniary sanction, the employer shall not impose a pecuniary sanction. The word pecuniary in law, it's sort of like punishment involving money. Let me explain it simply as that. You cannot impose a pecuniary sanction on the employee for whatsoever the reason will be. The law is emphatic for whatsoever the reason might be, except for reasons stated in Section 70. And 70, one of those reasons is not lateness. Will be when we have to deduct your union dues under your own authority, or you have taken a salary advance, what we like to call staff loan. We have to deduct, blah, blah, blah. So those of you who take money from the employee's salary because it's late, you are infringing on the laws. Rather, take the employee through what we are recommending. Right.
All right. Thank you so much, Jeff. Let me take Esther's input. Esther.
Yes. Thank you very much, Dr. Bassay and Kwabena. That is what doctor has said already. The procedures that we set in our condition of service or collective agreements under the disciplinary procedures is very progressive. You have to, under circumstances like this, you have to do the coaching, then you do verbal warning and document it. You have to take note that verbal warnings have to be documented and put on file to show in the future in case it continues or it becomes very persistent and it's going to get to the next level. You have something to show as evidence that you have followed procedure. So you have to document your verbal warning. And most of our collective agreements and our condition of service, under the discipline, we write what to be done under circumstances like this. For example, the same offense, if you commit it, we give you coaching, we give you verbal warning, we've documented it. Within a year, it happens again, we continue, give you warning. First warning is there, second warning, because it's progressive. The third warning, most of the time, is a termination, because that means you don't want to fall in line. By the time you follow through this 1, 2, 3, get to the fourth point, most of the time the lateness is solved. At times, it's issues that come up. We know life happens, and people have personal or private cases or issues that they transfer to the job. So by the time you start your coaching and want to bring a first warning or query to ask, why have you been late this few days, months, or weeks? You coach the person, he tells you, because my wife is that, there's a pregnancy, there's a new childbirth, blah, blah. Then you understand why this is happening. Before you get to second warning, it's done. Unless the person has got another job or is becoming emotionally unstable, you solve it. But if the person is becoming emotionally unstable and you need a professional advice, you also know from the interactions you have with the person that this is not just an absenteeism issue, but it's just a personal something or the person is sick. Then you help the person take care of it. I had a case that I will have to give the person a casual leave or part leave to take care of his personal issue because the wife has just given birth. So for me, I'm just happy about this paternity leave. And they are in Accra alone, and he's the only person who have to take care of the wife and another small child. He has to send to school before coming to work. So people are shy, they can't have this discussion with their managers, maybe because of their relationship. So they just say, I want to be late. Let me take care of this first. So immediately you start talking to them, maybe it's 2, 3 days they need to sort their personal issues out and come back to work and work normal. So by the time we get to first, second warning, we are done with the problem. Then we continue living.
All right, thank you so much, Esther. We have just 8 minutes to go, but before we go, Doc, I want you to touch on the paternity leave. What does the law say? Is there anything we need to know about the paternity leave?
Well, paternity leave as of now is alien to our laws.
Whoa.
And just for emphasis, let me mention that there are only 3 leaves or 3 types of leave that are sanctioned by our laws. Only 3: maternity leave, annual leave, sick leave. Every other type of leave, well, maybe my colleagues may want to speak to it. I have never come across them. I'm not condemning them. They are good leave, like bereavement leave, or what we've come to know as compassionate leave, study leave, casual leave, leave of absence with or without pay, paternity leave. They are all not in our laws. So if an employer wants to if you may, grant those leaves, I just advise that you must regulate it and through your policy. To the extent that it's not stated in law, I can't recommend, or I cannot say the law say this is how it should be done. So if you intend to do it well. But I can tell you that a few companies have come to know in Ghana that do paternity leave. Some of them have even had a cause to recall the leave because they realize that the beneficiaries don't use the leave for its rightful purpose. your wife has put to bed and you're supposed to they go and be roaming about. And so that's what I have observed. But I think I heard in the grapevine, it wasn't grapevine, I think it was formally stated. I think the Minister for Finance in the previous budget, the immediate past mid-year budget review, indicated that it could be done. Paternity leave could be legislated. Until then, we cannot speak to it because we don't know what will be stated in the law. Right.
Thank you so much, Doc. I really appreciate it. So we have 5 minutes to end. I will pick just 2 questions from the comment section. But before that, I think I was talking about the new course we have coming up, which is the HR, so legal training for HR and line managers. So let me take you through why you have to attend this workshop. So we have expert instructors available. Dr. Jeff Bassay is one, and you can't miss. We have a comprehensive curriculum. We also have practical insights. So if you realize, all our conversation has been practical. And always don't forget that networking is something you can't put it on the ground. So you have the chance to network with a lot of people from different industries. And also, you will study these. So the course overview, you will study the foundation of law. You will also do workman compensation law 1, that is 1833. You also do the labor law 2023. You will also do employee discipline and termination, employee contracting, HR policies, and the law. So these are what we are going to take you through here at the HR Certification Center. So just in case you want to enroll on this professional course, we just want to call this number 020 800 7585. Let me take the number for the last time. 020 800 7585. So we are starting as soon as possible. So book your seat fast. And it is starting on October 9th, 2004 to November 2015. There's an online option too, so you can jump on the online option. Let me pick few questions in here, and then we call it a day. So there's a question from, so let me pick this question. No, let me pick, please can the handle, okay, let me pick this one. So this question is from Equation. Is suspension of any effect if the employee's salary cannot be deducted by law? I take the question again. I don't know who will tackle this, but I pray this goes to Dr. Jeff Bassay. The question says, is suspension of any effect if the employer's salary cannot be deducted by law? Is suspension of any effect if the employer's salary cannot be deducted by law?
I dare say that I think that our law is not sacrosanct on whether there can be a suspension without pay. Indeed, I know our time is almost up, but Kwabena, I think that it's good you take the questions and probably even take my colleagues' views on the question. Am I still audible, please?
Yes, doctor, you are audible. Yes.
Okay, that's fine. So I'm saying that if you can kindly take your time, take the response to the 2 questions, and my colleagues support responses. So I don't think there's anything absolutely indicated in our law on whether suspension can be with or without pay. Will I call it a lacuna in the law? Now, I am also yet to read any ruling on that. But to the extent that there have been nothing absolutely stated on it, and the law also mentions in section 69 the pecuniary sanction not to be imposed. We can only look at it on case-by-case basis. But to the second leg of your question, which is, would there be any other sanction or any effect? Somebody would say, oh, but if you suspend the employee and still pay the employee, then what is the punishment? There is still punishment there. There are companies who have policies on how 2 or 3 suspensions could constitute termination. So you committed this offense with suspended, you committed it again, blah, blah. So that's enough punishment. That 2 or 3 is more like 2 yellow cards will equal red card on the football pitch. All right. And then also in some companies, the policies clearly indicate that once you are suspended, it retards your progress on promotions. And so all of these things are some level of punishment to the employee in the event that you have to suspend the employee and still pay, and you are wondering, and then we are just asking him to go and rest. No, there are consequences. On the file of the employee, you have been suspended 2 or 3 times. That is why you cannot be promoted, etc. Okay, so that is what I have to say to this very controversial issue of suspension with or without pay.
Thank you, Doc. Let me also ask this question, Mr. Stephen. Stephen, if you are here, let me.
Kwabena, hello, Kwabena.
Hi, Madam Esther.
Before the next question, like on the suspension.
Okay.
Like Doc said, it depends on the policies we've signed to. Before this discussion of suspension with pay or without pay came into the limelight for us to be looking at it, whether we have to suspend with pay or without. Suspension was without pay because we saw it as one of the disciplinary procedures, the end disciplinary procedures for a grievance I mentioned for a disciplinary issue if you fall foul of the laws or the rules that we've set. And it's clearly stated that if you've done A, B, C, and through the disciplinary procedure, the committee recommended suspension as a measure. And we are all HR people discussing these days that suspension should be without pay. But I read something they put on one platform, and the cases from the court is saying that if the rules that we have set in our workplaces that we are going to suspend without pay and we sign on to it, then it's there. We have to follow through. But if we don't have anything in our policy, in our condition of service, in our collective agreement, and it's open, then we cannot suspend the person without pay. That is what I read from a court ruling. I don't know whether I read well. So all depends on the rules we have set for ourselves as a company or as an organization to follow through. So immediately you sign on to that, you know that it's going to be, and like a doctor said, it's also when you are suspended, whether they pay you or not, even the stigma that you carry, because a few work environments that have been, immediately the person is suspended. When he even comes back, he feels very embarrassed, intimidated. You see the person very quiet for some time before he will get back to his own self and started working. So for the psychological punishment alone is something. So that is what I have to say. You have to set the rules before you use it. But if you don't have any rules in your book says that, or policy in your book says that suspension without pay is what happens under these circumstances, you can't just get up and be using it.
Thank you so much, Esther. So, Stephen, let me ask you this question. As a question from Irene. So Irene is asking, is it okay when sick leaves are deducted from your annual leaves?
Okay, so it is not okay. Let me just begin by saying that so that nobody begins to have a feeling that, oh, then maybe in the near future we can do something of that nature. Now, the reason why I am saying this is this. I remember my very first time meeting Dr. Bassay. We were having a certain discussion on an issue, and one of the things he said has stuck with me till date. So we were having a conversation. He goes like, Stephen, but you are aware that sickness doesn't have a start and end date. So in that same manner, You cannot say that you're going to deduct a person's sick leave from his annual leave. You know why? Because when you get malaria, you don't determine when your malaria should go. When you suffer any work-related injury, it is not up to your body to determine that in 5 days you will be fine to go back to work. So this whole idea of capping, and I have seen other places where in their policy or in their procedures, there's a cap on sick leave, that for the whole year you are entitled to 10 days as sick leave. How would you be able to determine which sickness will give you 2 days of sick leave? Which sickness will give you 5 days of sick leave? So it's a no-no from the very beginning. There's a reason why sick leave is administered by a medical practitioner and not the HR. So it is the attending medical practitioner who would say, looking at this particular injury or this ailment that you are suffering, stay home for 5 days, stay home for 2 weeks. Some even bring you excuse duties that cover like a month if they are having pregnancy issues or it's a high risk pregnancy, and the doctor says that person should be given bed rest. If you have that in your policy now, how are you going to put the two together? Because the doctor is saying your employee should be placed on bed rest. You too, you are saying that your sick leave, you are going to deduct from my annual leave. So if I am supposed to stay in bed for 3 months, I am not sure that you would have a sick annual leave that would allow an employee to be away from work for 3 months. So it would defeat that purpose. So please, Irene, you cannot deduct sick leave from annual leave. It's against the law. And the labor laws are pretty clear on what each leave is supposed to serve. And just like Doc said, there are only a few that is recognized: your annual leave, your maternity leave, your sick leave. So they work in they take different parts. They are not summed together because at the end there's the mention of leave. So no, Irene, you cannot deduct a person's sick leave from his annual leave.
Yeah, Steve, I think Irene can read Section 24 of the Labor Act. It's clear. Sick leave not to be computed as part of annual leave.
Irene, I hope that you are satisfied now.
Yes, I'm sure she is. I'm sure. Thank you so much, Stephen. But before we end this session, Doc will give us an update. But hold on, I have a good news for everyone on this platform. So the HR Certification Center is organizing a corporate camp experience, which is happening from the 1st of August to 31st of August to 1st September at the Ebri Botanical Gardens. So the fee is 780 Ghana cedis. The activities include board games, soccer, old school jam night, fitness build, and managing stress talk. You can't miss this. So just in case you want to sign up, just pick the number from the screen and our team will attend to you. Doc, last question before we end. What changes should we anticipate with the new Labor Act? Is there any changes we should anticipate with the new Labor Act? Hello, Jeff. Can you hear me?
Oh, I can hear you. I think Auntie Esther can look at it. Me, I'm not anticipating anything.
Doctor,
yes,
you are here. One of it is the paternity leave.
Yeah,
it's part of the new additions that have gotten into the draft.
Okay.
Labor Act. Then the second one that I've noticed is the maternity leave, the extension. Previously, or in the existing Labor Act, we have 12 weeks, but now we have 14. That's what is in the draft. What I've also noticed is that part of the provisions under the Shops and Offices Act has found itself a glimpse of it in the new draft. I don't know whether Stephen too have noticed it, about the inspection and the provision of changing rooms and water. They also found itself in the new
Yeah.
draft because they were at first they were in the Shops and Officers Act. Then what else have I noticed? If you look at the duties of the duties and rights of the employer and the worker to a little extension is there, giving the two parties a lot of responsibilities. But one thing I have to let all of us who are on call here is that note is that those of us who are workers, we don't read the law. The only thing we want to do is to work until we have issues. So we have to be reading the law and know our rights and our responsibilities. And this sick leave question that the lady has asked you is also a few things have been added. And what else? Those are the things I can remember of head about the new insertions in the arts.
Thank you so much, Madam Esther, for that. So,
Mhm.
hi, Stephen.
Yes, Kwamna, I'm here.
Yeah, yeah. Do you have something for us? I heard your voice.
Yes, so there are some few additions to. I think
Okay,
Auntie Esther has largely spoken about some of the new additions, but one of the things we must also notice this. Now, the issues about workman's compensation is going to be under the new labor law when it's finally passed into law. Now it's a bill. So
okay,
in the bill, as it is now, the workman's compensation law, i.e., the PNDC law 187, is a standout statute on its own. However, with the introduction of the labor bill, it is going to be a part of what will now be our new labor act, so that we'll not have a different law to deal with workman's compensation. We are putting that into the labor law as well. So now it will no more be known as the workmen's compensation. We are changing the terminology to now reflect. So the whole idea is that it should be gender neutral. So now it's no more going to be workman's compensation. It's going to be worker compensation.
okay,
So we are taking away the men that came earlier with it to now to read just worker compensation. And I think some of the additions would also relate to the entities that regulate the employment relationship in Ghana. So there's some expanded obligation on the labor department. Same has also been done with the labor commission, because the present constitution does not allow it to do a lot of things that ideally it should be seen to have been doing.
okay,
So when that also comes into force, what it would mean is that now the commissioner can actually impose administrative fines on persons who fail to comply by its decisions. Earlier, it has to go and do that through the courts. Now, with the new bill, it means that the commission can now go ahead when you refuse to comply with its directive and issue, an administrative fine in the form of a penalty for you to pay. So just like Auntie Esther has mentioned, one of the things that we must do as HR people, it hasn't become law yet. Currently, it's a bill. I think
okay,
that we will do ourselves a lot of good if we begin to know what is in the bill before it becomes law, because a lot of the sections are going to change. What we used to know under the Act 651 is going to change, because rights and responsibilities of the employer and the worker are moving from sections 8 to 11 to about sections 20 something to 30 something. So if you don't start reading now, when it actually becomes law, you would have a problem trying to catch up, because you will be confusing the session. So it's on all of us. And I think that's the call from my very own auntie in respect of HR people trying to update themselves by reading is very important. It's available. You can have access to it, read it, and also try and get a copy of the concept note behind the review, so that you understand why all of those changes are being introduced. Because I didn't really understand why they are now going to call workmen's compensation worker compensation until I read the concept notes. Because then the idea is we want to make it gender neutral, so that for gender activists, it will not look like it is too masculine in nature. People have raised concerns over it, so now we are making it gender neutral. So those are some of the new additions that have been made.
Thank you so much, Steve. But still, where can I get a copy to buy or?
Okay, so if you want a copy to buy, you can visit the Assembly Press.
Okay.
You can also check online. I'm not too certain about online, but I know that if you know how to use the internet, you should get a copy. What I can also do is that I think I have a copy in my email. I can share with you so that if any person wants a copy, they can reach out to the center and then you can just make it available to them.
All right. Thank you so much, Stephen. Before we conclude, I would like
Commoner, my hand is up.
Okay, Esther.
They've included something on harassment, and I'm just recalling because I've read it over a month plus now. So there's something very specific on harassment and bullying also that we have to be careful of as HR people. Understand what it is. Let our legal people explain to us so that we explain to our team members. So that in those days it was only the men who have been harassing the women, but now it's both. So we have, those are the things that could carry us to the commission, the law court, or labor department, or wherever. Then there's provisions on children employing younger people. There's a provision on it, and there's a setup of some committee. I can't get through it well, but we need to read it and understand the implications that it will have on our roles as HR people and workers. So harassment is very important to me, because when he says that a person can take herself or himself out of the company when he feels harassed, at times we HRs, we are afraid of people who are the tingles around us, and we close our eyes on things. This could bring us trouble. So we have to read and start reading now.
All right.
And Stephen, it's one of my problems. So when I look at the draft bill and I say, hey, this Labor Act that I can't say I'm Awini Baba.
I know
where I can find redundancy. I know how I can find this. I know how I can find. Now the whole thing is
it's
plenty.
crazy.
And I'm now going to start all over again. I don't know. So
if I show you my labor law now, so what I have done is that you know those the stick pads that you can stick to make notes on.
Yes.
What I've done is that I have taken my time to do. Okay, so this is now under this particular clause. This is now under this particular clause, because now they are going to. I think they are changing the sections to read clauses rather. Not sections as we are used to now. So now it's going to be clause 1, sub clause 1, clause 3, sub clause 3, 1. Those things. That's how they are going to do it. So it's, trust me, Auntie Esther, I share in your sentiment. But we'll get there. We'll get used to it.
We'll get there. We'll start. I've read through this thing twice, but I still can't stick in my mind yet.
We'll be fine. We'll be fine.
Yo, thank you.
So Esther and Stephen, we'll get there. Myself, we'll get there. So we want to take this time to thank everyone on this platform for making us Brand of the Year HR Training Services. So we just want to take this time to thank everyone who has been following HR certification since we started operating, and also to say, without you, HR certification wouldn't have been where we are now. So I want to thank you for your time. Just to close our session, I want to take the chance to educate us all on the opportunities that are currently here at HR certification. So the first one is the opportunity to enroll in our legal training for HR managers, HR and line managers. So this is a big opportunity if you are an HR, if you're a line manager, if you manage people. I believe you don't have to miss this course. Once again, we have another workshop on ethics. So this is another course that we are starting effective 28th of August 2024. The fee is 600 Ghana cedis and is online. 100% online. So take advantage now. And lastly, corporate camp experience. Corporate camp experience. You can't miss this year's corporate camp experience, which is happening at Ebri Botanical Gardens. And lastly, we just want to encourage you all that cohort 40 starts from 7th of September. We are taking off 7th of September. So if you haven't signed up, please do call us on 0244 122 855. 0244 122 855 for the APHRI, PHRI, and SPHRI courses. On this note, we want to take this opportunity to thank our facilitators, Stephen Osei-Kisi, Esther Fefoame, and Dr. Jeff Bassay for their insightful discussion. So we take a closing remark from Dr. Jeff Bassay and we call it a day. Doc, if you are here, could you please give us a closing remark?
Well, nothing much to say than to say a big thank you to you for the invitation, and also to our colleagues, or my colleagues, Steve and Esther, and then to everyone else who had the time and the patience to listen to us, to go through this with us. Never stop, learning the labor law, especially if you are interested in people management issues. I have the same problems as Esther is going to have now, where you know where every section is. I used to brag that the entire Labor Act cover to cover is in my head. I don't refer to read from section 1 to 179 all in my head. I guess I have to do it all over again when the new one comes. And I want to encourage everyone. Let's all learn these things well. It helps. It boosts your confidence level when you are managing your workers and your team members. Thank you all, and let's all enjoy the rest of our weekend.
Thank you, Dr. Jeff Bassay. Thank you once again for joining us today. We look forward to seeing you all at our future event. Stay safe, stay informed, and have a wonderful evening. Don't forget, keep learning. As Dr. Jeff Bassay said, never stop learning. Thank you all, and enjoy your evening.
Why do 93% of the world's leading multinational companies prefer certified professionals? Because they tend to be committed to higher standards and ethics and maintain an informed intercultural competency. Whether you're seeking to build a career or to upgrade your HR professional career, you need to get trained and certified at the HR Certification Center today. Our experience in training and certifying HR professionals is unparalleled. We're trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide, and today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or WhatsApp today on 0244 122 855.